it procedurally gets messy because the jury convicted of murder, not attempted murder. But if you put that aside, let's just assume all this happened at the trial level, and the jury had been instructed, and he'd been charged with attempted murder. Ladies and gentlemen of the jury, to convict Dlugash of attempted murder, you must find that under the attendant circumstances as he believed them to be, he would have been guilty of murder. Then you can convict him of attempted murder. The jury says, the circumstances as he believed them to be were that Geller was alive, he shot him 5 times, that would have been murder, so he's convicted of attempt. Okay?
But it says in here, like, as a defense, you could say that he intended to give a blow of mercy. So
He intended
maybe
what?
to give him a blow of mercy. So, like, not intending to murder, but to, I guess, spare him extra suffering. Is that ever something that could change intent enough to get
Why do
somebody
we,
off?
we don't care about that in this case because the jury convicted him of murder. The jury didn't buy that.
Yeah.
Okay? Second, that is going to, more generally, if that is the defense, that it was a mercy killing, that's going to depend on the statutes in that particular state. Some states, under some limited circumstances, do allow for euthanasia, right? They wouldn't in a case where somebody gets shot 5 times. But let's assume it was, my long-suffering spouse who's been suffering from this debilitating illness asked me to give them an overdose of medication, and some states might allow that. Right? The states are not required to allow for euthanasia, but they can. So, but not in a Dlugash kind of situation. Good luck with that.
Like, best case scenario with that kind of argument, could you get it to where maybe you're not convicted of murder, but they bring it down to like manslaughter or something?
No. I mean, best case scenario, maybe you can plea bargain that, but not in terms of, I don't even think you get a jury instruction on that. Because, it happens to be the doctrine of some religions that you look at the primary purpose, and if it's a quote-unquote side effect of achieving that purpose, that somebody dies, that's permissible morally. But that's not the way the law treats it. The law treats it as if you end a life and it was your intent to end this life, it's murder.
So why do they even mention that the jury could conclude that?
Because it's a question of his intent. The jury could conclude that he had that intent, but they didn't because they convicted him of murder.
Yeah.
I don't think coup de grace, they didn't mean it to mean like mercy killing, right? They just meant the last shot.
Oh, yeah, yeah.
That is that like the that's how I
Yeah,
read
the
it.
coup de grace there is, finish him off.
Not
Finish him
mercy.
off like, I'm the straw that breaks the camel's back.
So the other guy that shot him in the chest, was the outcome the same in his trial? Because he probably was arguing that he didn't kill him by shooting him in the chest.
Well, what's the outcome for Dlugash?
For Dlugash?
What's the ultimate outcome for
Attempted
Dlugash?
murder.
And what would be the ultimate outcome with that argument in mind for Bush? Let's say you can't prove beyond a reasonable doubt that Bush's shots killed him.
Well, he definitely was trying to, though.
And so, what's the
Attempted
outcome?
murder.
Attempted murder.
So do you know if that's what happened?
I do not know, but that would certainly work.
It's in the footnotes, it says, Joe Bush pleaded guilty to a charge of manslaughter.
Oh, okay.
Plea bargain. That's, plea bargain. We're talking about what would have happened if he'd gone to trial. If he'd gone to trial, I think he clearly could have been convicted of attempted murder.
Yeah.
But, when you plea to avoid a trial, to save resources, etc., it works for both sides. Now, what actually happened to Dlugash? This seems like it's neat and wrapped up in a package. So, if you want to read the footnotes, what else do you find out?
Never retried.
I'm sorry?
It says never retried. Both sides were.
Because look at 760 note 1.
Oh, no.
Remember, we said that the reason you could simply use the murder verdict to say, oh, this is what the jury did conclude. It necessarily concluded that Dlugash believed Geller was alive. Dlugash was later granted habeas corpus relief by a federal district court in New York because that's actually wrong, just to make things a little more complicated, right? And the reason it's wrong is because New York law permitted the jury, under the instructions, to presume his intent from the act of murder rather than requiring them to find it. Remember, this whole thing, this whole line of reasoning used by the Court of Appeals hinged on saying the jury necessarily made this finding about belief. But if they are allowed to presume it, that undermines that, or it actually causes that whole line of reasoning to collapse. So the New York Court of Appeals, the federal district court said, no, he at least needs a new trial, and that never happened because they didn't reach the agreement. Okay? So I wanted to highlight that because this is an important element of the way appellate courts function. When they say there was a problem below in the trial with the jury instructions, with evidence, but they have a verdict before them, they can try to use that verdict to then maybe foreclose or render unnecessary a subsequent trial. But it requires them to be able to say that it was a necessary conclusion that the jury in the first case actually reached. If there's a reason why there's some doubt about that, they have to send it back for a new trial. And that's what, as it turns out, the New York Court of Appeals really should have done in this case. Okay? This is important. That's the way you have to look at that question. Proceed. Okay? Any other questions about Dlugash? If you sort of clear all the other cobwebs aside and look at the case in the most simple way, it's really a pretty straightforward application of the Model Penal Code rule, right? Under the circumstances as Dlugash apparently, we don't know for sure, believed them to be, it would have been murder, therefore it's attempted. Since the circumstances weren't or couldn't be proved to be as Dlugash believed them to be.
So under the common law rule, if Dlugash was using that as a defense,
I beg your pardon?
Under the common law rule, if Dlugash was using that as an offense or defense, you could say that it'd be a legal impossibility because
I love this question. You're my favorite person in the world.
the act is, well, I'm just like,
Oh, I get it.
the act is completed would be criminal because he would be shooting a dead human being.
And that is legal because?
Wouldn't it be a legal impossibility?
I'm sorry?
Wouldn't that be a legal impossibility?
Because, and why is that legal impossibility? Explain how you would argue that that's legal impossibility, not factual.
Because it can't be in his hand.
It's not about intent, it's about how we treat, think of it related to the top code.
Okay, well, the completed act, shooting a dead body is not.
Because of something about the legal status of that body or that object, if you want to call it that, right? Right? The legal status of a live person is different than the legal status of a corpse when it comes to murder. Just like the legal status of a top coat when stolen is different from the legal status of a top coat when restored to its owner. That would be the argument that it's legal. How would be the argument that it's factual? It's there.
Maybe because you don't know if the body is dead or not, like you're not certain, so.
More simple. This is simple. This is simple.
You can't kill a dead body.
And what is that about?
It's a fact.
It's about a fact. Was Geller dead? That's a fact. And what does that tell you? This whole distinction is mind-numbingly useless. Right? When you can say it's either legal or factual, and when we get to 1,000, we'll talk about hybrid. How many of you loved that? When you had gone through all this reading and you got to 1,000, and they said, oh, let's talk about hybrid, which is sort of saying the legal status of something factual. Then it can be this hybrid thing, and then you just throw up your hands and say, forget it. Now, I think this case, actually, Blue Gas illustrates that idea, that it can be hybrid too, that it can seem like both. And when it can seem like both, the whole distinction makes no sense. Right? So there are very good arguments in Blue Gas that it could be factual impossibility or that it could be legal, and that the common law rule would therefore face a nervous breakdown in trying to deal with it,
Do most jurisdictions use the MPC?
or some version of it, and Kentucky does. Let me give you this section of KRS. It is KRS 506.010 1A. 506.010 1A. All right, let's talk about 1,000.
Just really quick, kind of procedurally, in the jury instructions, would you put, like, if you find that the defendant thought the victim was alive, it would be murder or attempted murder, and then if you find that
thought he was alive?
if,
All that to get you is mens rea.
yeah, well, no, I just like if they actually believe that he thought he was dead, did they put desecration of corpse like?
Might be desecration of corpse.
Yeah, like as another charge. So
Could be.
yeah, okay.
Okay, in 1,000, the Wayne County, this is like Dateline NBC. Right, this is Chris Hansen, the Chris Hansen case.
Yeah.
Do you remember that, Mr. Webb? Go ahead.
Mr. 1000 is a sexual predator who was discovered by Deputy William Levinsky.
Levinsky, I think.
Who was using a pseudonym of a 14-year-old girl named Becca online to find sexual predators for chat rooms. Mr. 1000, the screen name Mr. Automac, talked to this girl who believed to be 14 and had like a lewd conversation. Eventually sent a picture of his genitals and tried to meet up with her, set up a meetup with her.
And he did this despite indications of
Her age.
her apparent age,
Yeah,
Becca's age.
repeated
And he even asks, he even says, ain't I a little old? And Becca says, oh, no, because boys like my age act like little kids. And then there's all this conversation that is incredibly offensive about how he interacts with her. And eventually he says, oh, by the way, do you look at least 16? Because I may have to lie to my roommates. He's just a piece of work. So they arranged to meet on December 17th, and 1000 shows up. He doesn't chicken out, or it wasn't all just talk. He shows up to meet what he thinks will be Becca. He's dressed the way he said he would be, so she would know who he is. And he has 2 white teddy bears, because Becca had told him she liked those. And what does Levinsky do?
He looks around for 30 minutes and can't find her, so he's back in his car where he's arrested.
He's arrested. And he's charged with,
Attempt to distribute obscene material to a minor.
and why can't he be charged with actual distribution of obscene material to a minor?
Because there was no minor.
Because there was no minor. There was obscene material, but there was no minor, so it has to be attempt. What did the lower courts do?
So the trial or circuit court dismissed it because of impossibility. Appellate also wanted to confirm that, but then it went to the Supreme Court.
They say, look, it's impossible because a child, or the presence of a child, is an element of this charge, okay? So here we have a mistake by the defendant of law or fact, and because of that, his actions could not possibly have resulted in commission of the crime. So what does the Michigan Supreme Court say about that?
So they talk about the difference between legal and factual possibility. They determine, as was determined before, the factual possibility is no defense. So then they talk about legal impossibility and determine that it's divided into 2 subcategories of pure and hybrid. It's not pure because they talk about how this is not pure. Pure legal impossibility would be if the criminal law does not prohibit defendant's conduct for the result that she has sought to achieve, which is this is not in this case, it's not accurate in this case. So then they look at hybrid and they say essentially that hybrid could apply, but that hybrid and factual are virtually indistinguishable, logically indistinguishable,
Good.
they say, in this case, and therefore there's no defense.
Right, the court says hybrid is where commission of the offense was impossible due to a factual mistake regarding the legal status and some factor relevant to the conduct. And basically under that approach, if you introduce hybrid, Booth becomes a hybrid case because there was a mistake about some fact regarding the legal status of the top code. So all of a sudden we've turned legal into hybrid legal because factual elements are part of it. So the Michigan Supreme Court says, look, nothing in our statute precludes attempt here because of a factual mistake of any kind. A factual mistake that relates to legal status or otherwise, and the fact that he had this, what the court calls an extrinsic misconception, does not change the fact that he meets the elements of attempt, and therefore Dowson can be guilty. Questions about Dowson?
So, what they define as hybrid is it's the commission is impossible due to a factual mistake of a legal entity.
Factual mistake where it's like, I believe that the car was only worth $500, so it can't be grand theft. That's a factual mistake about the worth of the car, but it relates to the legal status of.
So a factual mistake of legal status.
Exactly. Any other questions? All right. I want to introduce to you your assignment. It's the box exercise on pages 767 and 768. Okay? The first one, the answers are in there. Guilty, factual impossibility, not guilty, and it sort of gets you started. Your exercise is going to be in your teams to fill in the box, fill in the blanks, and there is a blank form on Blackboard mirroring these that you can use to fill in on 768. And it relates to this circumstance. Congress has forbidden the delivery of obscene materials across state lines to a person known to be under the age of 18. And then when you go across the top in the boxes on 768, it says the age of the recipient is either 17 or 19, and then the defendant believes the age of the recipient to be either 17 or 19, right? And then number 2 and number 3, number 2 is at the bottom of 767, and number 3 gives you the instructions for the second set of boxes, gives you the assumptions you should be working under for each of them. Okay? So that's what I want you to do as a team. You're going to come up with only one answer as a team, and you should indicate don't just put not guilty or guilty. Tell me what they would be guilty of in your team's judgment. Right? Guilty of attempt, guilty of the completed crime, not guilty of either. Right? Give me that information. And if you are not unanimous, you can indicate that. Say something like, we had some disagreement on this, but this is the consensus we reached. You can do that, but I want one answer. Okay? Any questions? And obviously, if your team has questions as you start going through this, I'll be happy to answer those. You can come by my office and shoot me an email. That'll be fine. Okay? That's your assignment again. It's due next Wednesday at the start of the class. Bring it with you to class or email it to me as an attachment. That's fine. All right. I have your causation answers with my comments. I'm going to put them in 3 different piles to make life easier.